Howdy, everybody. I'm going to do a reading of Initiative 1495. It is the exact same thing as Initiative 1491, but I'm going to be reading 1495 from 1495. I don't know if it's because they just changed from 1491 to 1495. When you go to the group that's doing this, they have 1491 plastered all over their site, so I don't know for sure if it's changed to 1495 or if for some reason there's going to be two initiatives that are pretty much the exact same thing except for the name. The main reason I'm doing this is if you ever read the news, any of the media, you're not going to get any of this information from it. They don't the way the media works is they don't care about fact checking anything anyone says. They'll they just listen to what someone says and reports what they say. They don't do any kind of for the most part they don't or won't do any kind of actual in-depth checking to see if what someone says matches the word of the initiative they're trying to pass. Uh, one of the main one of the things that also kind of prompted me to do this was this post here, which many people have a problem with because the they're they're basically what the sign this lady has there is a blatant lie. She's getting signatures for 1495 initiative 1495, but has a sign that says protect your right to bear arms, Constitution, Second Amendment, protect your rights. And it's it's it gives me it's an issue to me because they're blatantly just lying about what it is they're doing this gun control group. Uh, Anyways, I'm gonna start reading now. Uh, Initiative Measure Number 1495, Section 1, the intent of this initiative. Oh, yeah, I'm also going to be putting in my commentary whenever I feel like it, I suppose, as I'm reading through this. The thing you're going to, if you're not willing to listen to me read this, you should vote no. If you're not willing to go off and read this whole initiative yourself and understand this, this initiative, you should definitely vote no. There's no reason to vote yes for something you have no clue about or are even unwilling to read. Section 1 Intent. This act is designed to temporarily prevent individuals who are at high risk of harming themselves or others from accessing firearms by allowing family, household members, and police to obtain a court order when there is demonstrated evidence that the person poses a significant danger, including danger as a result of a dangerous mental health crisis or violent behavior. Now, I want to make sure you all understand this is the intent. This is not necessarily what the initiative is going to do. It's only what they hope the initiative will do. It's, if you want to understand intent, go see, the Affordable Care Act or the Patriot Act. Section 1. 2. Every year, over 100,000 people are victims of gunshot wounds, and more than 30,000 of those victims lose their lives. Now, I wanted to go over this. I was going to look up the statistics for the number of people who use a firearm in murders, but I didn't pull that up. But I did pull up this site, which has a suicide statistics. The American Foundation for Suicide Prevention. I don't know if they have any kind of political bias to them, or if they have any, if they're looking for if there are any kind of anti-gun legislation or something like that. But right now, each year, 42,773 people die by suicide, and 25 people attempt suicide for every suicide that is gone through. So there's quite a significant number of people that are at least attempting suicide each year. That's 117 suicides per day. And firearms account for about 50% of all suicides. So out of that 30,000 number they gave, about 20,000 of them, 20,000 of the deaths related to the use of a firearm are by suicide. That leaves another 20,000 suicides by other means. Another thing to look at is, men, for every one woman that commits suicide, 3.5 or more men commit suicide, and 7 out of 10 of those suicides are white males, and the highest rate of suicide are middle-aged men. Now down here we can see a pie chart that shows that firearm accounts for 49.9% of total suicides, and everything else is suicide. So if guns were completely removed from the planet, you'd still have a very significant amount of people committing suicide. Over the last 5 years for which data is available, 164,821 people in America were killed with firearms, an average of 91 deaths each day. Studies show that individuals who engage in certain dangerous behaviors are significantly more likely to commit violence towards themselves or others in the near future. These behaviors, which can include other acts or threats of violence, self-harm, or the abuse of drugs or alcohol, are warning signs that the person may soon commit an act of violence. Individuals who pose a danger to themselves or others often exhibit signs that alert family, household members, or law enforcement to the threat. Many mass shooters displayed warning signs prior to their killings, but federal and state laws provided no clear legal process to suspend the shooter's access to guns, even temporarily. In enacting this initiative, it is the purpose and intent of the people to reduce gun deaths and injuries while respecting constitutional rights by providing a court procedure for family, household members, and law enforcement to obtain an order temporarily restricting a person's access to firearms. Court orders are intended to be limited to situations in which the person poses a significant danger of harming themselves or others by possessing a firearm and include standards and safeguards to protect the rights of respondents and due process of law. Now, if you go back to the statistics I gave you, What really gives me issue with this is the people that are promoting this initiative. They're not actually concerned about the person. They're concerned about the object, the firearm. They're concerned about the firearm. If they can take your firearms, they don't care. They don't care about the issues the person is having, or that the person is a potential violent criminal. They just want to take their firearms. They don't care anything about actually preventing people from committing suicide. I'm convinced that if somehow all guns were to just disappear into oblivion, it wouldn't reduce firearm suicides by 20,000. Some of those 20,000 who committed suicide with a firearm would just switch over to those other means of poisoning, suffocation, or whatever other may be. So, you might reduce suicides, but you can't really know for sure. And then right here we got Section 2, the short title. This act may be known and cited as the Emergency Protection Order Act. Now, I haven't fully read through this yet, but with my glancing through, I, in comparison to what a protection order is, I would consider this more, if I were to give this a title, I would call this the Assault Order Act. And once I get to that area, hopefully I will explain why I would call it the Assault Order Act. Section 3, Definitions. The definitions in this section apply throughout this chapter unless the context clearly requires otherwise. 1. Emergency Protection Order means an ex parte temporary order or a final order granted under this chapter. Now, I'm going to admit right here, I have no clue whatsoever what ex parte means. I mean, just by that word alone, if as far as I know, it's not really English. No average person, most average people aren't going to understand that word, so I would not. Yeah, I would not. That's one. Just the words they use in these laws they want passed should keep you from wanting to vote this in, at least in my opinion. 2. Family or household member. The term family or household member means, with respect to a respondent, any person related by blood, marriage, or adoption to the respondent. B. Dating partners of the respondent. C. Person who has a child in common with the respondent, regardless of whether such person has been married to the respondent or has lived together with the respondent at any time. D. Person who resides or has resided with the respondent within the past year. E. Domestic partner of the respondent. F. Person who has a biological or legal parent-child relationship with the respondent, including step-parents and stepchildren and grandparents and grandchildren. And G. Persons who is acting or has acted as the respondent's legal guardian. So they seem to be going pretty broad with defining there. You don't even have to be a member of the household to be a household member, apparently. 3. Petitioner means a person who petitions for an order under this chapter. Respondent. Or 4, the term respondent means the person who is identified as a respondent in a petition filed under this chapter. Section 4. Petition for an emergency protection order. There shall exist an action known as a petition for an emergency protection order. 1. A petition for an emergency protection order may be filed by a family or household member of the respondent. Now remember, we're talking about the term family or household member, and we're not talking about the actual definition of family or household member. Or B, a law enforcement officer or agency. 2. An action under this chapter must be filed in the county where the petitioner resides or the county where the respondent resides. 3. A petition must A. allege that the respondent poses a significant danger of causing personal injury to self or others by having in his or her custody or control, purchasing, possessing, or receiving a firearm, and be accompanied by an affidavit made under oath stating the specific statements, actions, or faults that give rise to a reasonable fear of future dangerous acts by the respondent. B. A petition must identify the number, types, and locations of any firearms the petitioner believes to be in the respondent's current ownership, possession, custody, or control. C. A petition must identify whether there is a known existing protection order governing the respondent under Chapter 7.90, 7.92, 10.14, 9A.46, 10.99, 26.50, or 26.52 RCW, or under any other applicable statute. And D, a petition must identify whether there is a pending lawsuit, complaint, petition, or other action between the parties to the petition under the laws of Washington. 4. The court administrator shall verify the terms of any existing order governing the parties. The court may not delay granting relief because of the existence of a pending action between the parties or the necessity of verifying the terms of an existing order. A petition for emergency protection order may be granted whether or not there is a pending action between the parties. So it appears, so basically, so it seems that the emergency protection order doesn't have to be bogged down by any other things, that any other kind of orders. 5. If the petitioner is a law enforcement officer or agency, the petitioner shall make a good faith effort to provide notice to a family or household member of the respondent and to any known third party who may be at risk of violence. The notice must state that the petitioner intends to petition the court for an emergency protection order or has already done so, and include referrals to appropriate resources including mental health, domestic violence, and counseling resources. The petitioner must attest in the petition to having provided such notice, or attest to the steps that will be taken to provide such notice. 6. If the petition states that disclosure of the petitioner's address would risk harm to the petitioner or any member of the petitioner's family or household, the petitioner's address may be omitted from all documents filed with the court. If the petitioner has not disclosed an address under this subsection, the petitioner must designate an alternative address at which a respondent may serve notice of any motions. If the petitioner is a law enforcement officer or agency, the address of record must be that of the law enforcement agency. 7. Within 90 days of receipt of the master copy from the administrative office of the courts, all court clerks' offices shall make available the standardized forms, instructions, and informational brochures required by Section 16 of this Act. Any assistance or information provided by clerks under this section does not constitute the practice of law, and clerks are not responsible for incorrect information contained in a petition. 8. No fees for filing or service of process may be charged by a court or any public agency to petitioners seeking relief under this chapter. Petitioners shall be provided the necessary number of certified copies, forms, and instructional brochures free of charge. 9. A person is not required to post a bond to obtain relief in any proceeding under this section. 10. The Superior Courts of the State of Washington have jurisdiction over proceedings under this chapter. Additionally, district and municipal courts have limited jurisdiction over issuance and enforcement of ex parte emergency, well, there's that word again, yeah, protection orders issued under Section 6 of this Act. The district or municipal court shall set the full hearing provided for in Section 5 of this Act in Superior Court and transfer the case. If the notice and order are not served on the respondent in time for the full hearing, the issuing court has concurrent jurisdiction within the Superior Court to extend the ex parte emergency protection order. Maybe if I ever run into one of the people that are promoting this initiative, I'll ask them what ex parte means. Section 5. Emergency Protection Order Hearings and Issuance. Upon receipt of the petition, the court shall order a hearing to be held not later than 14 days from the date of the order and issue a notice of hearing to the respondent for the same. Yeah, what frustrates me is, oh, this reading sucks. You know, I think you're gonna have, anyone's just gonna have to read this through this a few times in order to get it, actually understand it, because half the time I'm just reading through it without really even paying attention. A. The court may schedule a hearing by telephone pursuant to local court rule to reasonably accommodate a disability or in exceptional circumstances to protect a petitioner from potential harm. The court shall require assurances of the petitioner's identity before conducting a telephonic hearing. B. The court clerk shall cause a copy of the notice of hearing and petition to be forwarded on or before the next judicial day to the appropriate law enforcement agency for service upon the respondent. C. Personal service of the notice of hearing and petition shall be made upon the respondent by a law enforcement officer not less than 5 court days prior to the hearing. Service issued under this section takes precedence over the service of other documents, unless the other documents are of a similar emergency nature. If timely personal service cannot be made, the court shall set a new hearing date and shall either require additional attempts at obtaining personal service or permit service by publication or mail as provided in Section 8 of this Act. The court shall not require more than 2 attempts at obtaining personal service and shall permit service by publication or mail after 2 attempts at obtaining personal service unless the petitioner requests additional time to attempt personal service. Personal service. If the court issues an order permitting service by publication or mail, the court shall set the hearing date not later than 24 days from the date the order issues. The court may, as provided in Section 6 of this Act, issue an ex parte, that term again, emergency protection order pending the hearing ordered under this subsection 1. Such, what do we got going on here? Such ex parte order must be served concurrently with a notice of hearing and petition. 2. Upon hearing the matter, if the court finds by a preponderance of the evidence that the respondent poses a significant danger of causing personal injury to self or others by having it in his or her custody or control, possessing, or receiving a firearm, the court shall issue an emergency protection order for a period of 1 year. For a whole year, this emergency protection order will exist. And you haven't actually been convicted of a crime or anything of the sort, but your rights will, at least your right to keep and bear arms, will be revoked for a whole year. 3. In determining whether grounds for an emergency protection order exist, the court may consider any relevant evidence, including but not limited to any of the following: a recent act or threat of violence by the respondent against self or others, whether or not such violence or threat of violence involves a firearm. You would think that if the violence happened, they would already be under some kind of, either in a jail cell or out on bail, waiting to go to trial for a crime. B. A pattern of acts or threats of violence by the respondent within the past 12 months, including but not limited to acts or threats of violence by the respondent against self or others. Again, these people should, the whole emergency protection order should be the least of your worries. Sound like these people should be in jail waiting for their trial. C. Any dangerous mental health issues of the respondent. Now that's gonna be an interesting thing there as we go along. A violation by the respondent of a protection order or a no contact order issued under Chapter 7.90, 7.92, 10.14, 9A.46, 10.99, 26.50, or 26.52 RCW. Again, if a person has violated a protection order, they have committed a crime. The whole emergency protection order should be the least of anyone's worries at this point. E. A previous or existing emergency protection order issued against the respondent. Why would you need to issue another emergency protection order? The only thing that emergency protection order does is that's different from a protection order is it takes away your firearms. F. A violation of, it takes away the person's firearms. F. A violation of a previous or existing emergency protection order issued against the respondent. Now right there, that's going to be, down the line here, that will be kind of be an issue there. Because the problem is, if you haven't necessarily been convicted of a crime when you have a protection order against you or this emergency protection order. And there is a criminal act related, essentially being being in possession of a firearm is a criminal act if you have an emergency protection order. So, anyways, I'm gonna maybe address that more towards the end. G. A conviction of the respondent for a crime that constitutes domestic violence as defined in RCW 10.99.020. Again, that person probably is sitting in jail if they were convicted of domestic violence. I don't know why you would need or why they'd even give you an emergency protection order if you're sitting in jail. I mean, if they serve their time, they're no longer really a criminal. H. The respondent's ownership, access to, or intent to possess firearms. Yeah, right there. That's. Wait, what were we looking at? Oh, so just simply, they're saying that simple ownership, access, or even the intent of a person to possess a firearm is evidence for an emergency protection order. Just because you own a firearm, that someone can get an emergency protection order against you, apparently. So that can be a dangerous little thing there. I. The unlawful or reckless use, display, or brandishing of a firearm by the respondent. Well, that's generally a crime, an actual crime, and someone's gonna be sitting in jail if you're just shooting at the wall of the store or shooting across the street just for fun or whatever you want to call it. J. The history of use, attempted use, or threatened use of physical force by the respondent against another person, and the respondent's history of stalking another person. Again, I don't understand why you need an emergency protection order here, because this person is either already going to be prohibited from owning a firearm, or they're going to be sitting in jail for committing an act of violence. K. Any prior arrest of the respondent for a felony offense or violent. Now, I would have to question whether this is arrest. That I'm not sure if that conviction counts. If someone was arrested, I mean, you can be arrested, but you can be completely innocent of what they arrested you for. So they could arrest you for the idea that you committed a felony offense or violent crime, but if you're found not guilty, then you weren't convicted of a felony offense or violent crime, but you were arrested for it. So another really, that just being arrested, can be grounds to get an emergency protection order and have your firearms taken away. 1. Corroborated evidence of the abuse of controlled substances or alcohol by the respondent. And, oh, that was L. L, sorry. Looked like the number 1. So, the evidence they can give in order to get an emergency protection order against you is that you abuse controlled substances. You're an abuser of controlled substances or alcohol. It's not that you're gonna have evidence of recent acquisition of firearms by the respondent. An emergency protection order. The evidence against you is you purchased a firearm. Got it. 4. The court may A. Examine under oath the petitioner, the respondent, and any witnesses they may produce, or in lieu of examination, consider sworn affidavits of the petitioner, the respondent, and any witnesses they may produce. The thing about this is you're putting this person on trial, but you're not. If people are it's you're putting this person on trial. It's a assumption of guilt, and not this assumption of innocence. And that, for me, is it's wrong. It's immoral. It's immoral. Doesn't matter whether or not they seem like a person who could might do something, commit some kind of violent act. It's just immoral to go out and take away the rights of people who have committed no crime. B. Ensure that a reasonable search has been conducted for criminal history records related to the respondent. Now remember, this is the things the court may do. They don't necessarily have to do it. They may do it, not shall. They don't have to actually do these things in order to give the emergency protection order. 5. In a hearing under this chapter, the rules of evidence apply to the same extent as in a domestic violence protection order proceeding under Chapter 26.50 RCW. Only difference between a regular protection order and an emergency protection order is the fact that they get to come and take your guns. 6. During the hearing, the court shall consider whether a mental health evaluation or chemical dependency evaluation is appropriate, and may order such evaluation if appropriate. This is interesting because as as it is, you're not being you're not being you're not being accused of a crime. You're just being you're just being you essentially have someone who's afraid you're going to do something, and now you're having to go to court to prove your innocence. 7. An emergency protection order must include A statement of the grounds supporting the issuance of the order, B, the date and time the order was issued, C, the date and time the order expires, D, whether a mental health evaluation or chemical dependency evaluation of the respondent is required. Isn't that fun? You're not being convicted of a crime, like other protection orders, but you're being required to maybe required to submit to this stuff to prove your innocence. E, the address of the court in which any responsive pleading should be filed. F, a description of the requirements for relinquishment of firearms under the Section 10 of this Act. And G, following statement. To the subject of this protection order, this order will last until the date and time noted above. If you have not done so already, you must surrender to the insert name of local law enforcement agency all firearms in your custody, control, or possession, and any concealed pistol license issued to you under RCW 9.41.070 immediately. You may not have in your custody or control purchase, possess, receive, or attempt to purchase or receive a firearm while this order is in effect. You have the right to request one hearing to terminate this order every 12-month period that this order is in effect. Starting from the date of this order and continuing through any renewals, you may seek the advice of an attorney as to any matter connected with this order. That's interesting that they even take the concealed pistol license. You see, you haven't been convicted of a crime, but you have to give up everything. Give up all your firearms and your concealed pistol license. And I would imagine that you'd probably have to go and, if it's all over, you'd probably have to spend another 50 some bucks to get a new concealed pistol license. 8. When the court issues an emergency protection order, the court shall inform the respondent that he or she is entitled to request termination of the order in the manner prescribed by Section 9 of this Act. The court shall provide the respondent with a form to request a termination hearing. 9. If the court declines to issue an emergency protection order, the court shall state the particular reasons for the court's denial. Section 6. Ex parte, that word again that nobody would actually know what it means. Emergency protection orders. A petitioner may request that an ex parte emergency protection order be issued before a hearing for an emergency protection order without notice to the respondent. Fun. By including in the petition detailed allegations based on personal knowledge that the respondent poses a significant danger of causing personal injury to self or others in the near future by having in his or her custody or control, purchasing, possessing, or receiving a firearm. The protection order, you already have a protection order, but you want to get their firearms taken away from them. 2. In considering whether to issue an ex parte emergency protection order under this section, the court shall consider all relevant evidence, including the evidence described in Section 5(3) of this Act. 3. If a court finds there is reasonable cause to believe that the respondent poses a significant danger of causing personal injury to self or others in the near future by having in his or her custody or control purchasing, possessing, or receiving a firearm, the court shall issue an ex parte emergency protection order. The court shall hold an ex parte emergency protection order hearing in person or by telephone on the day the petition is filed or on the judicial day immediately following the day the petition is filed. 5. In accordance with Section 5(1) of this Act, the court shall schedule a hearing within 14 days of the issuance of an ex parte emergency protection order to determine if a 1-year emergency protection order should be issued under this chapter. An ex parte 6. An ex parte emergency protection order shall include a statement of the grounds asserted for the order, b. the date and time the order was issued, c. the date and time the order expires, d. the address of the court in which any responsive pleading should be filed, e. the date and time of the scheduled hearing, f. a description of the requirements for surrender of firearms under Section 10 of this Act, and G, the following statement. To the subject of this protection order, this order is valid until the date and time noted above. You are required to surrender all firearms in your custody, control, or possession. You may not have in your custody, control, purchase, possess, receive, or attempt to purchase or receive a firearm while this order is in effect. You must surrender to the insert name of local law enforcement agency all firearms in your custody, control, or possession, and any concealed pistol license issued to you under RCW 9.41.070 immediately. A hearing will be held on the day and at the time noted above to determine if an emergency protection order should be issued. Failure to appear at the hearing may result in a court making an order against you that is valid for 1 year. You may seek the advice of an attorney as to any matter connected with this order. Just by the context of this, it appears that ex parte means an immediate, that, without even confronting you, they can give a protection order, and you have to give up they surrender all your firearms and your concealed pistol license. And if you don't do so, and they discover that you have your firearms still when you go to fight your this order, you can get in trouble. 7. Any ex parte emergency protection order issued expires upon the hearing on the emergency protection order. Well, that's nice. So once you go in to deal with this protection order, it expires, except if you didn't get rid of your guns, you broke the protection order. 8. An ex parte emergency protection order shall be served by a law enforcement officer in the same manner as provided for in Section 5 of this Act for service of the notice of hearing and petition, and shall be served concurrently with the notice of hearing and petition. If the court declines to issue an ex parte emergency protection order, the court shall state the particular reasons for the court's denial. Section 7. Service of emergency protection orders. 1. An emergency protection order issued under Section 5 of this Act must be personally served upon the respondent, except as otherwise provided in this chapter. 2. The law enforcement agency with jurisdiction in the area in which a respondent resides shall serve the respondent personally, unless the petitioner elects to have the respondent served by a private party. 3. If service by a law enforcement agency is to be used, the clerk of the court shall cause a copy of the order issued under this chapter to be forwarded on or before the next judicial day to the law enforcement agency specified in the order for service upon the respondent. Service of an order issued under this chapter takes precedence over the service of other documents, unless the other documents are of a similar emergency nature. 4. If the law enforcement agency cannot complete service upon the respondent within 10 days, the law enforcement agency shall notify the petitioner. The petitioner shall provide information sufficient to permit such notification. 5. If an order entered by the court recites that the respondent appeared in person before the court, the necessity for further service is waived, and proof of service of that order is not necessary. 6. If the court previously entered an order allowing service of the notice of hearing and petition or an ex parte emergency protection order by publication or mail under Section 8 of this Act, or if the court finds there are now grounds to allow such alternative service, the court may permit service by publication or mail of the emergency protection order issued under this chapter as provided in Section 8 of this Act. The court order must state whether the court permitted service by publication or service by mail. Returns of service under this chapter must be made in accordance with the applicable court rules. Look at that, we're page 12 of 21. Section 8. Service by publication or mail. The court may order service by publication or service by mail under the circumstances permitted for such service in RCW 7.90.052, 7.90.053, 26.50.123, or 26.50.085. Accepting summons must be essentially in the following form. In the Court of the State of Washington for the County of ... petitioner versus number ... respondent, the State of Washington to ... respondent. You are hereby summoned to appear on the ... day of ... year at ... a.m. p.m. and respond to the petition. If you fail to respond, an emergency protection order may be issued against you pursuant to the provisions of the Emergency Protection Order Act, Chapter 7 RCW, the new chapter created in Section 18 of this Act. For 1 year from the date you are required to appear, an ex parte emergency protection order has been issued against you, restraining you from having in your custody or control, purchasing, possessing, or receiving any firearms. You must surrender to the insert name of local law enforcement agency all firearms in your custody, control, or possession, and any concealed pistol license issued to you under RCW 9.41.070 within 48 hours. A copy of the notice of hearing, petition, and ex parte emergency protection order has been filed with the clerk of this court. A copy of the notice of hearing and petition has been filed with the clerk of this court. Petitioner. Now, what you'll have to remember is that the person, when you're getting an emergency protection, since the emergency protection order is only about firearms, they essentially know you have firearms. So if they find out you don't give them up, then you'll get in trouble. 2. If the court orders service by publication or mail for notice of an emergency protection order hearing, it shall also reissue the ex parte emergency protection order, if issued to expire on the day of the emergency protection order hearing. 3. Following completion of service by publication or by mail for notice of an emergency protection order hearing, if the respondent fails to appear at the hearing, the court may issue an emergency protection order as provided in Section 5 of this Act. Section 9. Termination and renewal of orders. 1. The respondent may submit one written request for a hearing to terminate an emergency protection order issued under this chapter every 12-month period that the order is in effect, starting from the date of the order and continuing through any renewals. You only have one chance to get rid of the emergency protection order that's been filed against you for a whole year. A. Upon receipt of the request for a hearing to terminate an emergency protection order, the court shall set a date for a hearing. Notice of the request must be served on the petitioner in accordance with RCW 4.28.080. The hearing shall occur no sooner than 14 days and no later than 30 days from the date of service of the request upon the petitioner. Just to make sure it's clear, you have not been convicted of any crime, but your right to bear arms is taken away from you, and you only have one chance per year to essentially restore your right to keep and bear arms. And if you can't get that restored, you have to wait a whole nother year or until the emergency protection order is lifted or expires. B. The respondent shall have the burden of providing by a preponderance of the evidence that the respondent does not pose a significant danger of causing personal injury to self or others by having in his or her custody or control, purchasing, possessing, or receiving a firearm. The court may consider any relevant evidence, including evidence of the considerations listed in Section 5.3 of this Act. See right there, there you go. You have to prove your innocence. You're assumed guilty of, well, you're guilty of no crime, but you have to prove you're innocent of the crime of someone thinking you're gonna do something violent. C. If the court finds after the hearing that the respondent has met his or her burden, the court shall terminate the order. Well, I would sure hope so. 2. The court must notify the petitioner of the impending expiration of an emergency protection order. Notice must be received by the petitioner 105 calendar days before the date the order expires. That's a interesting amount of days. Wonder how they came up with that number. 3. A family or household member of a respondent or a law enforcement officer or agency may, by motion, request a renewal of an emergency protection order at any time within 105 calendar days before the expiration of the order. A. Upon the receipt of the motion to renew, the court shall order that a hearing be held not later than 14 days from the date the order issues. I, or little I, this goes under A. The court may schedule a hearing by telephone in the manner prescribed by Section 5.1a of this Act. The respondent shall be personally served in the same manner prescribed by Section 5.1b and c of this Act. B. In determining whether to renew an emergency protection order issued under this section, the court shall consider all relevant evidence presented by the petitioner and follow the same procedure as provided in Section 5 of this Act. It's interesting, after a whole year of not committing any crime, someone or doing any kind of act of violence, someone can say, "Oh, I'm gonna continue to take away your rights." C. If the court finds by a preponderance of the evidence that the requirements for issuance of an emergency protection order as provided in Section 5 of this Act continue to be met, the court shall renew the order. However, if after notice the motion for renewal is uncontested and the petitioner seeks no modification of the order may be renewed on the basis of the petitioner's motion or affidavit stating that there has been no material change in relevant circumstances since entry of the order and stated the reason for the requested renewal. D. The renewal of an emergency protection order has a duration of 1 year, subject to termination as provided in subsection 1 of this section, or further renewal by order of the court. Section 10, I believe this is where I should be showing why I would call this an assault order and not a protection order. Upon Section 10, surrender of firearms. 1. Upon issuance of any emergency protection order under this chapter, including an ex parte emergency protection order, the court shall order the respondent to surrender to the local law enforcement agency all firearms in the respondent's custody, control, or possession, and any concealed pistol license issued under RCW 9.41.070. 2. The law enforcement officer serving any emergency protection order under this chapter, including an ex parte emergency protection order. Assuming I figured out the definition of ex parte, which might be is like an immediate protection order where you don't have to go through any actual real hearing. It's just like, oh, it's I guess essentially an emergency protection order. Shall request that the respondent immediately surrender all firearms in his or her custody, control, or possession, and any concealed pistol license under RCW 9.41.070, and conduct any search permitted by law for such firearms. Law enforcement officers shall take possession of all firearms belonging to the respondent that are surrendered in plain sight or discovered pursuant to a lawful search. Alternatively, if personal service by a law enforcement officer is not possible or not required because the respondent was present at the emergency protection order hearing, the respondent shall surrender the firearms in a safe manner to the control of the local law enforcement agency within 48 hours of being served with the order by alternate service or within 48 hours of the hearing at which the respondent was present. Now, what's important to understand here is the emergency protection order is given because it is known that the person that the protection order is being filed against is in possession of firearms, which means when this ex parte emergency protection order happens, they have to give up their firearms no matter what. Otherwise, they have violated, immediate. If they don't give them up when the law enforcement officer comes to take them, or comes to receive, or pick up the firearms being surrendered, then the order has been violated. But the protection order, is likely to allow for what would be considered a lawful search because this emergency protection order is, it's essentially known that the person had the firearms, so the law enforcement are going to search for the firearms, and since you did not surrender them, you will be violating that emergency protection order. in which I believe we'll be seeing what happens when you violate the protection order here soon. 3. At the time of surrender, a law enforcement officer taking possession of a firearm or concealed pistol shall issue a receipt identifying all firearms that have been surrendered and provide a copy of the receipt to the respondent. Within 72 hours after service of the order, the officer serving the order shall file the original receipt with the court and shall ensure that his or her law enforcement agency retains a copy of the receipt. 4. Upon the sworn statement or testimony that the respondent has of the petitioner or of any law enforcement officer alleging that the respondent has failed to comply with the surrender of firearms as required by an order issued under this chapter, the court shall determine whether probable cause exists to believe that the respondent has failed to surrender all firearms in his or her possession, custody, or control. If probable cause exists, the court shall issue a warrant describing the firearms and authorizing the search of the locations where the firearms are reasonably believed to be and the seizure of any firearms discovered pursuant to this search. There you go. Your assault order. You haven't committed a crime, so they know that you have firearms because the whole point of the emergency protection order is the fact that you have firearms. So they're going to find that you are guilty of possessing firearms, so they're going to have the probable cause. You know, if they don't get you the first time that they serve you the order, they're going to have the probable cause to come and seize your firearms, in which you will have committed the crime of violating the emergency protection order. So, ain't that nice? 5. If a person other than the respondent claims title to any firearms surrendered pursuant to this section, he or she is determined by the law enforcement agency to be the lawful owner of the firearm shall be returned to him or her provided that a. The firearm is removed from the respondent's custody, control, or possession, and that the lawful owner agrees to store the firearm in a manner such that the respondent does not have access to or control the firearm, and b. The firearm is not otherwise unlawfully possessed by the owner. 6. Upon the issuance of a 1-year emergency protection order, the court shall order a new hearing date and require the respondent to appear not later than 3 judicial days from the issuance of the order. The court shall require a showing that the person subject to the order has surrendered any firearms in his or her custody, control, or possession. The court may dismiss a hearing upon a satisfactory showing that the respondent is in compliance with the order. See, not only are they going to take your firearms, but you have to prove that you've given up your firearms. You are going to be forced to go into court to prove that you have surrendered your firearms. Wow. You've committed no crime. And you're not being accused of a crime. But you have to go to court to prove that you have surrendered your firearms. 7. All law enforcement agencies must develop policies and procedures by June 1, 2017 regarding the acceptance, source, and return of firearms required to be surrendered under this chapter. Section 11. Return and disposal of firearms. 1. If an emergency protection order is terminated or expires without renewal, a law enforcement agency holding any firearm that has been surrendered pursuant to this chapter shall return any surrendered firearm requested by a respondent only after confirming through a background check. Oh, fun! They took your guns from you. You haven't been convicted of any crime. The emergency protection order no longer exists. But if you have to go through a background check to get your firearms returned to you, that the respondent is currently eligible to own or possess firearms under federal and state law, and after confirming with the court that the emergency protection order has terminated or has expired without renewal. The better part, what's even crazier, is if you had the firearms and you weren't allowed to possess firearms under federal or state law before even the emergency, then you actually were committing the crime of being a felon in possession of firearms, and the emergency protection order should have been the least of anyone's worries there. The fact that you were a violent criminal in possession of firearms should have been, enough that you should have been tossed in jail. 2. A law enforcement agency must, if requested, provide prior notice of the return of a firearm to a respondent, to family or household members of the respondent in the manner provided in RCW 9.41.340 and 9.41.345. So when they give you your guns back, they're going to tell everybody. Fun. 3. Any firearm surrendered by a respondent pursuant to Section 10 of this Act that remains unclaimed by the lawful owner shall be disposed of in accordance with the law enforcement agency's policies and procedures for the disposal of firearms in police custody. Page 17 of 21. We're almost done, I think. Section 12. Reporting of orders. 1. The clerk of the court shall enter any emergency protection order or ex parte emergency protection order issued under this chapter into a statewide judicial information system on the same day such order is issued. 2. The clerk of the court shall forward a copy of an order issued under this chapter the same day such order is issued to the appropriate law enforcement agency specified in the order. Upon receipt of the copy of the order, the law enforcement agency shall enter the order into the National Instant Criminal Background Check System. Any other federal or state computer-based system used by law enforcement or others to identify prohibited purchasers of firearms, and any computer-based criminal intelligence information system available in the state used by law enforcement agencies to list outstanding warrants. The order must remain in each system for the period stated in the order, and the law enforcement agency shall only expunge orders from the system that has been expired or terminated. Entry into the computer-based criminal intelligence information system constitutes notice to all law enforcement agencies of the existence of the order. The order is fully enforceable in any county in the state. So you're going to be prohibited from even purchasing a firearm as long as the order exists, even though you've never been convicted of a crime. Not only are they going to take your guns, but you're going to be unable to buy a gun as long as that order is in place. And it's going to be for a full year. They're not concerned about the person, they're just concerned about getting the guns. 3. The issuing court shall, within 3 judicial days after issuance of an emergency protection order or ex parte emergency protection order, forward a copy of the respondent's driver's license or identicard or comparable information along with the date of order issuance to the Department of Licensing. Upon receipt of the information, the Department of Licensing shall determine if the respondent has a concealed pistol license If the respondent does have a concealed pistol license, the Department of Licensing shall immediately notify the license issuing authority, which, upon receipt of such notification, shall immediately revoke the license. 4. If an emergency protection order is terminated before its expiration date, the clerk of the court shall forward the same day a copy of the termination order to the Department of Licensing and the appropriate law enforcement agency specified in the termination order. Upon receipt of the order, the law enforcement agency shall promptly remove the order from any computer-based system in which it was entered pursuant to subsection 2 of this section. Section 13. Penalties. 1. Any person who files a petition under this chapter knowing the information in such petition to be materially false or with intent to harass the respondent is guilty of a gross misdemeanor. 2. Any person who has in his or her custody or control purchases, possesses, or receives a firearm with knowledge that he or she is prohibited from doing so by an order issued under this chapter is guilty of a gross misdemeanor. Here we go. You're not convicted of a crime, and except you will be committing a crime by possessing a firearm or by receiving a firearm. If you go, if you have one of these orders and you go to a shooting range and you borrow a gun and shoot at targets, you're committing a criminal act. And further is prohibited from having in his or her custody or control purchasing, possessing, or receiving, or attempting to purchase or receive a firearm for a period of 5 years from the date the existing order expires. However, such person is guilty of a Class C felony if the person has 2 or more previous convictions of violating an order issued under this chapter. You see that? 5 years. You can go through the whole process of the emergency protection order and just have it completely lifted. If it was just complete, if it turns out there was no grounds to have that protection order, no real grounds to have that protection order against you, but you violated that protection order, that emergency protection order, you are not allowed to touch a firearm for 5 years. How's that? Section 14. Law enforcement retains other authority. This chapter does not affect the ability of a law enforcement officer to remove a firearm or concealed pistol license from any person or conduct any search and seizure for firearms pursuant to other lawful authority. Section 15. Liability. Except as provided in Section 13 of this Act, this chapter does not impose criminal or civil liability on any person or entity for acts or omissions related to obtaining an emergency protection order or ex parte emergency protection order, including but not limited to reporting, declining to report, investigating, declining to investigate, filing, or declining to file a petition under this chapter. Section 16. Instructional and informational material. 1. The administrative office of the court shall develop and prepare instructions and informational brochures, standard petitions, and emergency protection order forms, and a court staff handbook on the emergency protection order process. The standard petition and order forms must be used after June 1st, 2017 for all petitions filed and orders issued under this chapter. The instructions, brochures, forms, and handbooks shall be prepared in consultation with interested persons, including representatives of gun violence prevention groups, judges, and law enforcement personnel. Materials must be based on best practices and available electronically online to the public. A. The instructions must be designed to assist petitioners in completing the petition and must include a sample of a standard petition and order for protection order forms. B. The instructions and standard petition must include a means for the petitioner to identify with only lay knowledge the firearms the respondent may own, possess, receive, or have in his or her custody or control. The instructions must provide pictures of types of firearms that the petitioner may choose from to identify the relevant firearms, or an equivalent means to allow petitioners to identify firearms without requiring specific or technical knowledge regarding the firearms. C. The informational brochure must describe the use of and the process for obtaining, modifying, and terminating an emergency protection order under this chapter and provide relevant forms D. The emergency protection order form must include, in a conspicuous location, a notice of criminal penalties resulting from violation of the order. In the following statement, you have the sole responsibility to avoid or refrain from violating this order's provisions. Only the court can change the order and only upon written application. E. The court staff handbook must allow for the addition of a community resource list by the court clerk. 2. All court clerks may create a community resource list of crisis intervention, mental health, substance abuse, interpreter, counseling, and other relevant resources serving the county in which the court is located. The court may make the community resource list available as part of or in addition to the informational brochures described in subsection 1 of this section. 3. The administrative office of the courts shall distribute a master copy of the petition and order forms, instructions, and informational brochures to all court clerks, and shall distribute a master copy of the petition and order forms to all superior, district, and municipal courts. Distribution of all documents shall, at a minimum, be in an electronic format or formats accessible to all courts for court clerks in the state. 4. For purposes of this section, court clerks means court administrators in courts of limited jurisdictions and elected court clerks. 5. The administrative office of the courts shall determine the significant non-English speaking or limited English-speaking populations in the state. The administrators shall then arrange for translation of the instructions and informational brochures required by this section, which shall contain a sample of the standard petition and order for protection forms into the languages spoken by those significant non-English speaking populations, and shall distribute a master copy of the translation instructions and informational brochures to all court clerks by December 1st, 2017. 6. The administrative office of the court shall update the instructions, brochures, standard petition, and emergency protection order forms and court staff handbook as necessary, including when changes in the law make an update necessary. Section 17. Severability. If any provision of this act or its application to any persons or circumstances is held invalid, the remainder of the act or the application of the provision to other persons or circumstances is not affected. Section 18. Sections 1 through 16 of this act constitute a new chapter in Title VII RCW, and that's the end. If you made it through this, my rating of this, congratulations. As I said, you probably have to read through this a few times in order to truly understand it. And, well, if you're a person that's going to vote no, that, I truly believe this should be, this should not be passed. Um, if you're gonna, if you want actual information, if you want to know, if you really want to know about the initiative, you have to read it yourself. You're not gonna get any of this information from the media. You're not gonna be able to get on, on the you're not gonna be able to get any information about this initiative from the ones who support this initiative. I might do another video to sort of go over, just to kind of go over why, truly why you have to just go to, get your own information, read the information, and understand it yourself instead of trusting the media or thinking you're gonna figure it out from the people who made the initiative. Um, if anyone who supports this initiative, wants to have a debate with me, I'm up for it. I mean, you can try to get me on my Facebook page. I'm always up for a debate. I'd love to ask the people who support this questions about it and like how it. You know what? I'm just gonna end this here. I'll try to make another video.